Hello, everyone. Thank you for joining us today. I'm Marche, the webinar director at Advice Chaser. Before we introduce our guests and get started, we do need to do a little bit of legal housekeeping. Advice Chaser, the host of this webinar, is not a registered investment advisor. We cannot and do not give financial advice. Today's presentation is for educational purposes only and cannot be considered advice for any person's individual situation. Advice Chaser regularly hosts informative webinars such as this one, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, jokes, or principles expressed by presenters are their own and, however true, funny, or interesting, are not endorsed by Advice Chaser. Please do not act on the information you hear today without consulting a qualified financial professional. Well, we are thrilled to bring you today's educational presentation. Attendees are muted, but we do encourage you to ask questions using the chat box. And one caveat there, if you leave a question in the chat box and we're not able to get to that, go ahead and leave your phone number as well, and we will make sure someone reaches out to you after today's event. We want this experience to be as educational as possible, so please don't hesitate to reach out and ask for clarification or expansion of the material. So I would love to introduce you to today's guests. Our moderator today is David Eads, and he's the founder of Vital Investment Management and holds the designation of Certified Financial Planning Professional. Since he was 8 years old, Dave has had an affection for investments, which started with a fourth grade stock picking project at his elementary school. Dave possesses extensive experience in tactical investment strategies, comprehensive financial planning, and tailored retirement planning. Having spent many years in the investment industry, he can devise unique strategies to manage his clients' investments and personal finances effectively. Dave works hard to create a mutually beneficial and long-term relationship with his clients and their families. David's in the Northern Colorado area, but serves people throughout the country. And Dave will go ahead and come off of mute and say hello so people can see your face.
Hello, thanks for attending the webinar. Looking forward to it.
Very good. I'd love to introduce you to today's presenter. Will Byers is a native in Northern Colorado, and his practice focuses on estate planning, elder law, special needs planning, and Medicaid and VA issues. Will is licensed to practice in Colorado and has been accredited by the Department of Veterans Affairs to handle VA claims. He is a member of the Colorado Bar Association, Elder Council, Wealth Council, the Larimer County Trust and Estate Section, and the Larimer County Young Lawyers Association. His monthly columns on elder law issues can be found in the Larimer County and Weld County editions of 50 Plus magazine. Outside the office, Will is an avid Colorado Avalanche fan who loves skiing outdoors with his wife and son and their golden doodle. And that's just a little bit about our presenter. Will, I'm excited to have you present today, and I'm going to turn the time over to you.
All right. Well, thank you, Marche and Advice Chaser, and Dave Eads once again. Hopefully everybody attending today can find some interesting tidbits in this. But yeah, so today we are going to be focused on, do I need a special needs trust for my child? And so even though it's kind of focused from the standpoint of estate planning for the traditional families as far as what that even means anymore. But certainly, if you have any questions as to how this pertains to you and your certain circumstance, don't hesitate to ask any questions. That's really what we're here for. But yes, so how can really, just to give you guys kind of a start, as Marche relayed, our office, Byers Law, we really specialize in estate planning, and special needs planning is certainly a big component of that for families who have special needs family members. And so, most of these are going to be seen through the lens of a family who has a special needs child. So that's kind of where we're operating from. But again, this could really apply to if you have a brother that you want to take care of, really anybody in your scenario that may need that Medicaid or special needs planning component, that could apply to as well. And so really what we are looking at today is how we can effectively put together an estate plan for you in that scenario where there is a special needs individual who may currently be utilizing Medicaid or may be utilizing Medicaid in the future. We really just look at it as we want to have all options available for you and for your family members in the future, because I always tell the families who come into my office when we're starting this trail is that you are going to be your child's biggest cheerleader. You're going to know them better than anybody else. And so really just what we're trying to do is we're trying to put an effective plan in place that is going to keep all the doors open for not only the rest of your family, but certainly for that special needs family member as well. And so really the components of special needs planning, the biggest one that we tend to utilize when we are in this scenario is what's known as a third-party special needs trust. And so what this is essentially a standalone bucket that we would set up to hold the assets that you would be passing on to that special needs individual. With that in mind, there's often, some differing, I often like to liken estate planning to a tree trunk, and, traditional wills, trusts are the main trunk of that tree, but there are always these branches involved. And so a guardianship or a conservatorship, oftentimes that is something that is going to come into play as well, because, a child reaches 18, regardless of their circumstances, they are viewed as an adult pretty much across the United States. And so that is certainly a scenario where a guardianship or a conservatorship may become necessary. Now, if they are higher functioning, if they're on the autistic spectrum, or, their disability is more physical in nature, that may be a circumstance where a guardianship or conservatorship is not necessarily the most effective option. And so in that case, healthcare proxies or powers of attorney, sometimes they can be a less restrictive but also effective means of providing the ability for you to continue to maintain involvement in your child's day-to-day, their doctor visits, dealing with counselors, dealing with anybody else. Foothills Gateway, for example, in Northern Colorado, they're a great third-party outfit who kind of helps. They help families know what's available for their children based on their circumstances. And so that is where, when a child reaches 18, you're going to want to make sure that you still have those communication avenues in place, and that you aren't immediately shut off just because all of a sudden they're legally an adult. And so these are all kind of components that come into play when you're looking at an estate plan with a special needs individual involved.
Dave, I think we have some questions that came in. Maybe we want to address those now.
Okay, yeah, that sounds great. Can you do a guardianship or conservatorship before a child turns 18?
You can. I actually recently had to do those. Those are very, very case specific. Reason being that the reason for a guardianship or a conservatorship is to establish the legal ability for you to make decisions on their behalf. And so I was actually telling Marche, I recently had an unfortunate circumstance where a special needs child lost both of their parents in the course of a year. And so then it was the next of kin who was hiring me to help establish the guardianship so that they could reach out to their doctors, they could reach out to the schools, get that legal ability to communicate with these third parties on the special needs individual's behalf. So yes, there are certainly scenarios where that makes sense. But if you're legally the parent, if you're, whether biological, adoption, any manner, you are, the parent of record, so to speak, then you have an inherent ability to deal with third parties on their behalf. And so a lot of times it's not necessary, but that's not to say that it doesn't happen. As I recently had a scenario where because both parents were no longer in the picture, we needed to establish that legal ability for the next of kin to communicate with schools, to communicate with the doctors, to be able to take them to, the dentist and the psychologist and all of the other third parties who are going to be asking the question, hey, you're not Jimmy's parents, so what legal authority do you have to be talking with us and for us to be sharing these sensitive records with you? So certain situations, it can certainly make sense, but it's usually in that rare case where somebody who's not the biological parent or the adoptive parent needs to step in and kind of take over managing that role.
Okay. The other one was pretty high level. From a high level, why is Medicaid so important to an individual with special needs?
Well, so there's really two components to that, I believe. So number one is, with special needs planning, I have individuals who their financial component, kind of high level. The financial component is a big reason that Medicaid is something that we always want to keep on the table. I have clients whose children are higher functioning cognitively, but they have severe physical disabilities. I mean, it's certainly not unheard of to hear of children who have, $500,000 in medical expenses each and every year. And if that's the case, then, I don't know a lot of people who can be plunking $500,000 out of pocket every year and just be a-okay with that. And so in that case, you certainly want Medicaid to be an option that's available, particularly if, looking at it from a parental standpoint, if all of a sudden you're gone and somebody else is stepping into that role of making sure that the special needs individual is taken care of, that they're getting everything they need, you want every option available for them to ensure that, we're not leaving anything on the table. Now, the second standpoint is really it's kind of a case specific because I mentioned Foothills Gateway as kind of a local outfit that does a lot with counselors. They work with schools, they work with programs for special needs individuals, and certain programs are actually only available if you are on Medicaid. So there's also a component of there can be some restriction based on the programs available. And so that's another example where even if there's not a financial need for it, if they've been working with the same counselor for a very long time, I don't want them to all of a sudden be cut off from that because we didn't put in the tools in the toolbox for them to maintain Medicaid eligibility and to be able to have access to those resources.
Thank you.
Yeah, that was a high level question. You're right, Dave. So going back to the third party special needs trust, essentially what we're doing when we're setting up an estate plan and we have a special needs, third party special needs trust, usually it's going to be a parent or both parents setting up this third party special needs trust. And it's essentially just this empty bucket that we will then divert. So going back to a traditional estate plan, if you say, I have 3 kids, one of them is special needs, I want things to go a third among the kids. Well, with the special needs individual, we want to set up this third party bucket, and we want to then kind of, kind of set up a firewall where we are taking their third and we're putting it into this bucket upon the passing of the second parent. So reason for that is we set up this third party special needs trust in such a way that it is in compliance with federal Medicaid laws. And we check all the boxes and we do it in such a manner that says they can receive this property. And as anybody who's familiar with Medicaid knows, there are very strict resource requirements on Medicaid and Medicaid qualifications. So the whole reason for us setting up this third party special needs trust is to ensure that if you are leaving property to this special needs individual, that it is not going to put them at risk for Medicaid eligibility. And so we avoid that by setting up this line through the estate plan where anything that mom and dad are leaving to this special needs individual, it's going to go into the special needs trust, which is specifically created for this individual and for their needs and their wants and everything that goes on from a day-to-day standpoint that the parent of a special needs child has to deal with. And so it's a hyper specific solution to a problem that many people have to deal with. And really it's just setting up all the pieces, putting them in place so that when mom and dad are no longer around, we've got everything kind of funneling in an appropriate fashion so that they're not going to be exposed to losing anything that they currently have in place, and that they're also not going to lose the ability to put that into place in the future when mom and dad are gone. And one other benefit of a special needs trust, certainly this third-party special needs trust, is that with Medicaid, there are two types of special needs trusts. There's first-party special needs trust, and there's third-party trusts. And so a third-party trust is when mom and dad sets it up on behalf of a disabled individual. They can direct however much property they want to go into this special needs trust. They can say, we want it for the benefit of our son for as long as he's alive. And if there's property left in it at the end of the day, we want it to go to the other surviving children. That is a benefit that a first party trust is not afforded by Medicaid. And so usually where you see a first party trust is in the case of a medical malpractice, for example. So if somebody is disabled due to the wrongdoing of a third party, then the individual, the disabled individual, they're legally entitled to the property. So it's a little bit more convoluted, but essentially it all comes back to Medicaid's view of whose money is it that's at issue here. And so if mom and dad set up this third party trust, everything funnels into that third party trust. And sorry for making you jump back and forth, Marche.
That's okay. I just want the visuals to go with what you're saying.
No. And that's my fault. When mom and dad are setting something up on behalf of a disabled individual, they have the ability to put in whatever parameters they want. And so they can say, if there's money left over, we don't care how much Medicaid has had to pay on behalf of this disabled individual. This is how the property is going to go upon the special needs individual's death. That is a very exclusive right to a third-party special needs trust. You do not have that ability to do so with a first-party special needs trust.
Will, a quick question here. What sort of assets can go in trusts?
Any sort of assets can go into a special needs trust. I have put property, real property into special needs trusts. I have put, I've had special needs trusts as the beneficiaries of retirement accounts. I put brokerage accounts into special needs trusts. There's really no limitation on what kind of property can go into special needs trusts. And actually, without going too far into the weeds on this, Dave, but I know you're familiar with the Secure Act. And so the Secure Act actually allows a stretch out of retirement benefits for third-party special needs trusts that is not allowed to anybody outside of a surviving spouse. And so you actually have as many abilities to fund a third-party special needs trust as you do with any other traditional grantor trust that most people are familiar with as a traditional part of estate planning.
Thanks. Yeah, that's great.
There's a couple items on the slide here that you haven't talked about very much. Can you talk about what a spendthrift trust is, and then that last bullet point there?
Yeah. So really a third-party special needs trust is what's known as a spendthrift trust. And so what this means for our purposes today is that a child does not have to be, traditionally defined as disabled, and so typically, if somebody has Down syndrome, well, that's a pretty clear-cut example of, both medically and legally, an individual is going to be defined as, a special needs individual or a disabled individual. I have utilized third-party special needs trust in situations where there's alcoholism or there's substance abuse involved. And so really what it does is that this third-party trust, the individual who is the beneficiary, as it's known. So mom and dad set up a third-party trust, special needs trust for an individual. It doesn't have to mean that they are traditionally disabled, as you know, as we kind of colloquially refer to it. But I've utilized them in situations where somebody's a very high functioning individual, but they have a gambling addiction, or they just have substance abuse issues. They're prone to manipulation. But what it does is it says there is a third party who's not this individual who is going to be administering it on their behalf. And so the trustee has a lot of flexibility over how they can utilize those resources to benefit the special needs beneficiary in this case. And so, yes, going back to that last bullet point, a third-party special needs trust is not only for disabled individuals. It can be for anybody who is either, they're concerned about that Medicaid component, or a family's just concerned about their ability to manage their property on their behalf. And so that's really where it can come into play with higher functioning, autistic individuals, or somebody who has a severe physical disability, but cognitively they're pretty high functioning. And so there's a lot of different ways that we can utilize these. And I'm glad you kind of brought me back to this, Marche, because it's not just this rigid tool that we can only use when certain components are active.
Quickly here, Will, another question came in. Can you talk about rolling over a trust if the beneficiary passes?
Yes. So within the third-party special needs trust, if we set one, there's child A, B, and C, and child C is the disabled one that we're setting up a special needs trust for. Within that third-party special needs trust, we can say if child C, dies and there is trust property within that trust, we want the entirety of it to go to child A and child B. And so whoever the trustee is that is managing the trust on their behalf, if the child C passes away, then it would be the trustee's job to then relinquish the remaining assets to child A and child B. And that would be completely within the parameters of the parent's control. They could set it up so that if child C has children, it would go to those kids. They can also say, our other children, we want any remaining property to go over to them. If, our special needs trust has unused trust corpus, as it's known, there's trust assets left and child C passes away, they can then direct where exactly they want that remaining property to go.
Thank you.
So, talking to family, this is another great advantage of utilizing a special needs trust, and it's something that I have really started implementing more and more as a functional approach to how to put everybody into the best position possible. I have had a lot of family members come in and we've established a special needs trust for one of their children. And then as we're going on down the road and we're getting everything set up, someone will come to me and they'll say, hey, grandma or grandpa, they want to leave some money to this special needs individual. How do we go about doing that? Well, I actually have a form letter that I will send out to family members, that family members who are interested in leaving property to the special needs individual, we can kind of send them out a Cliff's Notes as far as how we would leave it to the special needs trust rather than leaving it to the individual themselves, so that, again, we're avoiding that disqualification from Medicaid, because again, we don't want anybody to be harmed based on the fact that grandma and grandpa or, great Aunt Sally, they want to do a nice thing and leave some money to this disabled child. There's a correct and easy, administratively efficient way to do it. And that's where kind of, starting to have those conversations and get those pieces in place can be incredibly advantageous, not just for, the people who are leaving property, but also to the disabled individual as well. And so again, we're just kind of putting all the pieces in place so that whatever the circumstances look like, we've got a means, we've got a way to get that property to them that's going to be utilized in a way that's not going to disqualify them from Medicaid. So, and let me just rearrange my my view. Okay, there we go. Okay, so who's the best kind of trustee? Oh boy, we could spend hours just on this guy right here. So as far as who is the best kind of trustee, that is really more and more I am leaning, and I'm counseling people on looking into somebody, a third party trustee that is familiar with special needs trust administration. I was actually telling Marche before we went live here that even as somebody who works with these day in and day out, if I found out tomorrow that I was listed as the special needs trustee for a family member, the first thing that I would do is I would reach out to some of the trust departments who I know and who I've worked with in the area, who are incredibly high level and familiar with administering these special needs trusts. I work with this stuff every single day, and there's just so many caveats. There's so many rules to stay on top of that. I want to make sure, I kind of look at the approach of who's the correct trustee. There are ways to involve the family members, the well-intentioned family members who want to look out and want to protect the individual involved. There's ways for them to be involved without having to be the trustee. And truthfully, the worst thing that can happen is putting too much on the plate of a well-intentioned family member. And so I think that it is a very, very appropriate use of the assets to use those that are going to be kind of designated for the special needs trust to give whoever the trustee is as much ability to hire good help as possible. And that is going to ensure that the individual involved, the special needs individual, that they're not going to be caught off guard because a well-intentioned family member, they checked the wrong box and they disclosed the wrong thing to Medicaid, and over some confusion, somebody has now been removed from Medicaid. That's the last thing that we want. And so even though obviously these third-party trustees, they're going to charge for their services, I do think it's something that is very important to at least look into and explore, because they are going to take an incredible amount of pressure and an incredible amount of work off of the plate of the individual who is going to be helping to take care of their brother or their sister or whoever, and just getting good help. And so I think that the best kind of trustee is going to be someone who is very familiar both with the circumstances of the individual, the special needs individual, but also who has a very, very thorough background, a very complex understanding of everything that goes in, everything that needs to be done. And truthfully, I think it is, I think it's borderline malpractice to have somebody who doesn't have a background in Medicaid kind of thrust into that position through no fault of their own, trying to steer the ship without good help. So I think that, if anybody ever calls me and they're a client of mine and they say, hey, Will, we're rethinking who we should have as, kind of the trustee, and you can always name a child as a co-trustee. I mean, that is completely legitimate. That is completely okay. And a lot of times I will name a child as a co-trustee along with a trust company who's, really kind of acts as that gatekeeper. They're making sure that the taxes are being filed, that everything's being done as far as what needs to be done for Medicaid. But you also have that family member in the room who is always going to have a hand in things and say, hey, this is what's best for my sibling, and I just want to make sure that that's accomplished. And so I would say that anybody who is exploring this, wherever you are, if an attorney does not spend a sufficient amount of time discussing the importance of having a trustee, an appropriate trustee for a third-party special needs trust, I would I mean, you could email me, you could email anybody else, but I think that is a very crucial component as far as how high level somebody is when they're looking at this kind of planning. And, really we're looking at what are things how are things going to be like when rubber meets the road? Because it's very easy for us to plan and to talk in hypotheticals while we're all around. But really, I look at it from the standpoint of, if I'm putting together a plan and it does not play out that way when mom and dad are gone, then somebody has dropped the ball, usually me. Somebody's dropped the ball along the way, because these are exactly the kind of conversations we want to have while mom and dad are alive, so that we can really get all the pieces in place that we need. So with that, we really wanted to keep this open for as much question and answer as possible, because this is truly one of those areas, and I've probably said this in all of my presentations, but this is just one of those things where it's like drinking from a fire hose. And so I hope that for each of you who have these questions, like, please feel free to send them our way. And I want to be able to kind of just hopefully answer them to the best of my abilities. But please feel free to kind of start shooting those over if anybody has any follow-up questions for me.
I have a handful here already.
Okay.
I can start down the list here. There's
Sure.
4 or 5. How early should a trust be set up?
So that is a good question. And truthfully, there's no right or wrong answer as far as how early a trust should be set up. I would say that with regularity, a lot of my, I guess my best practice clients, they will come in where they have got a special needs child who's not yet an adult, but they're coming in because they're doing their estate planning. And so right away, we can kind of start to get the pieces in place. And the nice thing about a third-party special needs trust is that mom and dad are going to retain the ability to alter, to manipulate that trust, to make changes as life brings about changes to their family and to their circumstances. And so I think that, anytime there's been a big life change, certainly if a child is, a special needs child is getting ready to become 18, that's a great time to come in and kind of start the conversation, talk about, hey, this is kind of what we're looking at. This is how we can set things up. But there's really, I hate this lawyer answer, but the earlier the better is truthfully always the best case, because, much like financial planning, Dave, the longer stretch you're going to have getting good advice in place and kind of implementing that good advice, the better off they're going to be in the long term, and the easier it is to adapt to things.
Perfect. How often should a trust be reviewed?
Oh, that's a great question. So part of our practice, and this is just based on what we've seen, if we are setting up a trust, this is both for a traditional, joint living trust, and certainly for special needs trusts as well. We have a complimentary review every 3 years, where if I haven't spoken with the client, I have on my practice management software, I have kind of a little ding that goes off and says, reach out to the Johnson family if you haven't spoken with them. And so I think every 3 years, even if it's just grabbing a cup of coffee with your attorney and just saying, hey, let's talk about what's going on with your family. Has there been any big changes? Has anybody gotten married? Any new, health issues or concerns? I think that, it's kind of like going to the doctor. I mean, truthfully, I'm never going to, especially now that I'm in my, my mid 30s, I'm not going to rely on what somebody told me 10 years ago as I'm healthy, and so there's just a level of life change that goes into it. And so I think, truthfully, if you're meeting with your attorney every 3 to 5 years and just kind of, keeping them abreast of what's going on with your family, you are going to be way, way, way ahead of the curve, truthfully.
Okay, thank you. Can you talk a little about what you'd expect to pay to have a special needs trust or program set up?
Sure.
Each attorney's different, but like a
Sure.
range.
Yeah, yeah. So I'll tell you typically what we do. If a family came in and they were just looking for a special needs trust, we do flat rates for our estate planning. And so if I was just setting up a special needs trust, usually that's going to be somewhere in the $2,000 to $2,500 range. This is reason for that is, partially kind of getting into our practice philosophy is that we don't charge for phone calls. We don't charge for emails. Reason being that this is a very complex area. And so I want to serve as kind of an ongoing resource for my clients because I have had, so give you a little background. I practiced with my father, Bill, who's been doing this for 30 plus years. And he was with a large firm. And one of the things that he always hated was it was a lot more expensive. It was a lot more cumbersome to clean up a mess after the fact because they were worried about getting billed for a tenth of an hour because they didn't want to call him and say, hey, we're thinking of moving a piece of property or we're going to be liquidating some assets. And how does this factor into what we've set up with you? And so that's kind of what we're operating off of in our price point as far as what a special needs trust is going to look like. So I think, usually 2,000 to 2,500 for a special needs trust is, it's tough because I've seen a $2,500 trust that I think is an excellent use of the funds. I've seen a $2,500 special needs trust that I wanted to throw in the trash immediately. So it's, I think if an attorney is not willing to kind of walk through these questions with you, I think transparency is a big thing. And just as one of the things I've always appreciated about Dave is that he'll tell you exactly what you're paying for, and I'm the same way. So I think that is kind of a good ballpark to keep in mind. But always, if they quote you a high fee or a low fee, that's not to say that it's going to be wrong or it's going to be out of line with, the market, but just don't ever be afraid to ask follow-up questions.
Okay, great. I have some more coming in. This is right off the press here. What can you do if a special needs child receives an inheritance from a will from someone who is not mom or dad after the fact, and it could affect their Medicaid?
Oh, so this is a very nice segue into ABLE accounts. So, John, I'm not sure if you are familiar with ABLE accounts, but every state now, there was a federal legislation that went through a couple of years ago that allows individuals to set up an ABLE account. So this is specifically for disabled individuals, who have a diagnosis prior to the 18th birthday that, whether it is, autism, whether it is any number of things, but anybody who has this diagnosis prior to 18, they can set up an ABLE account. So an ABLE account, it bears a lot of similarity with these 529 plans, which, Dave, do you know, is that Colorado specific or is that a federal thing?
I believe it's well, there's a Colorado ABLE program that you can use to invest, but I think it's like the 529s for college,
kind of administered the same.
Exactly. So state specific, but
yeah,
high level, it's federal.
Okay.
I just want to break in here, and it's the onset of disability before turning 26 years of age, not 18.
26. Okay. Thank you, Marche. And so 26 is actually that magic number. Now, I suppose with that, usually for the people who are going to be utilizing these, it's usually from birth, truthfully, but that's a very good point to bring up, Marche, because I've had people with CTE, for example, who later in life So that 26, anything prior to that, they can set up this ABLE account. So what this ABLE account is you can set it up on behalf of a disabled individual or a special needs child. And if it is, you can put in 15,000 a year from any source, really. And so, it would kind of be dependent on the amount involved. So one thing that I always tell people is that if there's an inheritance, let's say there's $40,000 that all of a sudden this special needs individual is receiving, first thing that I'm going to do is I'm going to set up an ABLE account. I'm going to plunk $15,000 into that account, because that is protected. That's not an available resource as far as Medicaid is concerned. So that's one way you can kind of take some off the top right away. And then also, if there are any costs, for example, if an individual has dental needs, if they have hearing aids, if they need a new wheelchair, anything like that, that's where right away I would take some of that money. If a perfect example would be if they need transportation. If you receive $70,000 and all of a sudden you're going, hey, this may disqualify our child from his Medicaid benefits, then start looking for a good vehicle to allow that you guys to adequately transport him to and from school and from doctor's appointments. That is a legitimate expense as far as Medicaid is concerned, and it could clear out some of that money, because as long as it's used for the benefit of that special needs individual, it's an acceptable use of the resource for Medicaid purposes. And so really what Medicaid does, and I apologize for kind of going a little bit in the weeds on this, is that if you receive that inheritance on the 15th of the month, when it rolls over to the 1st, it's considered a resource, an available resource to them. So time is of the essence. If you receive some sort of distribution, whether it's from a will or a beneficiary designation or something like that, call an attorney, a special needs attorney, because there's often going to be ways that you can really kind of shift that, use it for the benefit of the disabled individual, whether that's through an ABLE account or that is through purchasing any sort of dental work or anything that kids need. But you can kind of get that off the books, so to speak, so that Medicaid is not going to come back on the 1st of the month and say, hey, Jimmy has $20,000 in available resources. We're going to have to potentially disqualify him from Medicaid. So long-winded answer to that, but hopefully that kind of gives you an idea of what to do in that scenario.
That's great. Thanks, Will. A few other ones that I have here. What if you have multiple children with disabilities? Do you need a trust for each one?
So truthfully, best case scenario, yes, you do. Reason being that, it kind of what got us into the special needs realm was my own family's experience with Alzheimer's. And I can tell you, even just with 3, I'm keeping an eye on this, knock on wood, but 3 grandparents who had Alzheimer's, the layout of each scenario was completely different from the next. And so the reason that we like a specific, highly specific third-party special needs trust just for the individual is because Medicaid in Colorado, and again, I'm speaking to my experience with dealing with the Medicaid offices, kind of when the rubber meets the road, is that they will take any opportunity they can to disqualify an individual. And so if you have a higher functioning individual where you would like a little bit more freedom to do things with the assets that may not apply to the other disabled child, I like to have that firewall in there, because I only, if there's, Jimmy and John and they're both disabled and they have separate special needs trusts, I want John's to be hyper specific to his circumstances. I want Jimmy's to be hyper specific to his circumstances, because there's just less possibility for confusion on the Medicaid office's side of things. So I know that's a terrible answer, because that just means more legal fees. But in a perfect world, that is how I would like to structure things, because as I'm sure you can attest to, each one of your kids is going to be different. And so that's where I like to set these up specifically with the individual in mind when I'm putting together a special needs trust.
And can any estate lawyer set up a special needs trust?
They can, but they're not all, they're not, that's kind of like saying, the guy down the road can throw together a Ferrari the same way that, Enzo or any of the other guys can. So, what I will say, is that there are a lot of capable individuals out there. There are a lot of capable, attorneys who can set these up. But truthfully, I always like to, and this would be helpful to people who are kind of scattered throughout the US. If you have groups that you've worked with that are very special needs specific, I always like to ask them, hey, what attorneys would you suggest as far as this goes? Because I can tell you that my father has been doing this for many years. And over the years, attorneys have asked if they could borrow some of his special needs language. And my dad has immediately said, absolutely not. You have no business dabbling in this, because the ramifications can be huge. And that's really where I'm coming from when I say that just be careful, because one of the most frustrating things that I can attest to having seen is somebody goes in, they pay $8,000-$10,000 to have all these special needs trusts drawn up, and it's just kind of a plug and play solution to a very complex situation. And so, yeah, anybody can find the forms, but I just think that there's a level of due diligence that I'm never offended by somebody really kind of putting me through the ringer and asking, hey, what are your qualifications to do this? Like, what's your experience level? That's something that I think is a good question for any attorney who you're going to about setting up a special needs trust, is what is your level of practical experience in actually dealing with these? Because it's one thing to set it up in theory and say, hey, this is going to work. But I can tell you that there are specific provisions just based on Larimer County Medicaid offices that I will now take out or put in specifically based on those circumstances, because I know what they look for. So yeah, another long-winded answer. I apologize, but hopefully that, just never feel bad, never feel guilty about asking follow-up questions of the attorneys if you're looking at using them for this stuff.
Great. That was a good answer for that one. Do you find that some people set up trusts but don't fund them?
Oh God, yes. Yes, it happens way too often. And so kind of going back to our, that is an incredibly common problem across the board. And one of the most frustrating things for me as an attorney is having a parent pass away and the kids come in and they drop this stack of documents on my desk and they go, Mom and Dad had a trust from 1990. We don't know what it says. We don't know what's in it. And then, I've literally gone through records with a client in here and I said, well, hey, not to throw anybody under the bus, but this was never funded. That's one of those things that I have been so grateful having Dave as a resource, because the funding of the trust is every bit as important as having good documents in place. So part of our trust fee, and doing the flat rate for our work, is that funding component is part of that. I'm never going to charge a client, if they're working with Dave, to get on the phone with Dave or to set up a meeting with all of us and say, okay, Dave, what are you seeing on your side? What are the brokerage accounts? What are the retirement accounts? Let's go through the real estate dealings. Let's make sure that everything is going into the trust appropriately, because a trust does not work if it's not funded. So that is absolutely a problem that we see all the time. And so another good follow-up question for the attorneys would be, if you're going to them about a trust, whether it is just a traditional estate planning third party or revocable living trust, or it's a special needs trust, is what is your funding process? Is there additional fees, or do you, kind of lump it in with what we're going to be paying you? because that is a very high level question to ask as a potential client, is what does your funding process look like? And I can tell you right away, if somebody comes into me and they ask me that, I'm going to know they mean business. So that's a great way to distinguish yourself right away, and to know, if they're kind of stumbling over it and go, well, we don't, then maybe you look for other alternatives.
This question is one that you've touched on, but maybe you can get a little bit more insight. Can an outside party, not a sibling, be the trustee, say for a child who has no relatives that would be appropriate?
Absolutely. And that can be in any scenario. I have families with where there are living children, and I've had that talk with them about, everything that goes into special needs trust administration. And they've come to the conclusion, hey, we're going to have a third party, whether it is whether it's a bank that they've been working with, or whether it is a specific trust department that focuses just on administering these special needs trusts. And they work with somebody like Dave, or, your investment advisor, but that is absolutely an option. And so I think it's a great idea to know what all options are available, because like I said, there are ways to have the children involved and so if you want to do a little homework, a trust protector is something that I often utilize, where this trust protector, they wouldn't be the trustee. They're not going to be the one administering the day-to-day, but you can name a child or a family member or a close friend as a trust protector. They're not the ones filing the taxes or making the distributions for the special needs individual. But if they realize that needs are not being met by a trust company, then they can kind of hold their feet to the fire, and they can have the ability to swap out trustees and get a new corporate fiduciary in place to make sure that what the parents signed up for is what they're actually getting.
And can you review what trustees do, but what goes into the day-to-day for them?
Sure. So really what a trustee's role would look like in a special needs trust is, if mom and dad have an estate plan, and upon their death, it says, okay, we've got 3 kids, child A and child B, they're going to make, they're just going to get outright distributions from our estate, our state assets. And then this third party special needs trust is going to be set up for the benefit of our special needs child. Then the trustee's role is typically going to be where they step in after mom and dad are gone. They're going to wrangle up all the assets. They're going to put together kind of an Excel sheet of, hey, here's the real estate, here are the brokerage accounts, here's the investment accounts, here's kind of the final number of what assets were in place. We're then going to divvy them up. We're going to take the 1/3, put it into the special needs trust. And then we're going to work with, whether it's a care manager or the family members or whoever it is, and we're going to ensure that that special needs child, that their rent is being paid, or that they have a place to live, that they've got everything from a day-to-day standpoint that they need to continue to have, the best existence that they can possibly have. And so that's really where the trustee earns their fees, because then they could be working with somebody like Dave and say, hey, we've got $1 million in assets. We need to make sure this isn't just going under a couch somewhere. Dave, you invest that, make sure that we're getting returns. And then they kind of coordinate, set up a team approach, and they're kind of quarterbacking the trust, so to speak.
Yeah, that makes sense.
I think we have time for one last question here.
Okay. And this one just came in as well. In order for the special needs trust to be funded right away after the death of the parents, does that mean they need a trust too to avoid probate?
So typically, a trust is the most effective method to kind of have a clean probate-free, transition, so to speak. But I've had situations where beneficiary designations, obviously you guys are going to be familiar with that. And so let's say one, the asset makeup is such that a parent says, we're not overly concerned about probate, but we want the special needs trust to be able to hit the ground running. So we're going to take this $500,000 IRA and we're just going to set up the special needs trust as the beneficiary of this retirement account. Well, that's a great way that right away, Dave or whoever is, in that financial realm and has the contract as far as the beneficiary designation, that's where a probate wouldn't be necessary to kind of get that set up and funded. Now, if you just have all your assets, they just have to go through a probate before there's any sort of distribution that occurs, then yeah, you're going to have to open up a probate so that you can have the legal authority to transfer assets, among the beneficiaries. But as far as, administrative efficiency, I always prefer having a trust in place for the parents so that everything can kind of funnel through that. There's no need to get court involvement. And then we can just kind of have, keep it in-house, so to speak, so that we're not having to go to the court and say, hey, please grant us your blessing so that we can start moving these assets around and, get everything set up for the special needs individual and for the rest of the family. I'm just of the mindset that if I don't have to pay the court to be involved, I would rather not do that.
I think.
Well, very good.
Thanks.
Thank you so much. What an informative discussion. Both Dave and Will, thank you so much for being here. We want to thank the organizations that have made this webinar possible. To those of you who are on the call today, look for an email soon with a replay of this event, and you're welcome to share that replay with your friends and family. Here at Advice Chaser, we're all about helping you find a financial advisor who's a great fit for your life and your financial questions. Our matching service is free to you, and every one of our advisor partners has committed to offer a free initial consultation to anyone we introduce them to. Find out more by going to advicechaser.com and clicking on the link to find an advisor. Once again, from Advice Chaser, thank you so much for coming, and we will see you at another webinar soon. Dave and Will, thank you so much again.
All right. Thank you.
Bye, everyone.